Today's exciting episode, barristers behaving badly, and also, can you be extradited if you post something from abroad that the British police find offensive? The sort of answers to both those coming up shortly against the lovely backdrop of the Atlantic, which you'll have to take my word for it at the moment because it's a little bit murky and misty. But there you go. Right. Spin that round, try not to actually turn it off this time. Come on, people, come on, turn around. There we go. Okay, well, first of all, what about barristers? A lot of barristers are on social media. Some of them even just ramble on YouTube. Honestly, what's the profession coming to? But are we under sort of any obligations, or can we get into trouble for what we post? Well, sort of, yeah. As people may know, we are regulated by something called the Bar Standards Board. In the old days, it was actually the Bar Council that regulated us. But people pointed out and said, well, the Bar Council is effectively your trade union that defends you. So it's being the regulator as well. That seems to be a little bit of a conflict of interest. So in the same way, and I've just already wandered off into somewhere that's going to kill me, so I'll just just head back towards a path. So basically, we set up the Bar Standards Board, which was an independent regulator. Solicitors did the same thing because they used to be regulated by the Law Society. And they said, again, that's a conflict of interest, so that's why they have the SRA, the Solicitors Regulation Authority now. But the BSB have published some social media guidance for what we're allowed to do. And the tension is, should we be treated differently to, sort of quotes, regular lay people, members of the public? The BSB's view is, well, actually, yes, you should. Because, you know, of your professional status, if you're commenting on certain things, especially to do with the law, people might take that more seriously. There's also another reason I want to do this ramble, both metaphorically and literally, and I'll tell you about that shortly as well, all to do with my escapades in Sierra Leone. So what the BSB says, look, there's a thing called Core Duty 5. We don't really have a code of conduct. It used to be called the Code of Conduct. Now it's called the Handbook. I don't know why they call it a handbook, it's just a massive PDF document that you can't search on. One of my friends, check out Legal Style Blog on Twitter, he actually made a searchable version of it, which I actually know, because I go to the BSB meetings, that the BSB themselves actually use rather than their own one. But that recognises that, first of all, we have sort of professional status that might mean people take things more seriously or give us more credibility, especially on legal topics. But also, we have our Article 10 rights. That's your freedom of expression under the European Convention of Human Rights. Although we've always had a common law. I mean, people say, oh, there's no freedom of expression in the UK. We've always had a common law right. There's a case called Redmond Bates and DPP, which was all about sort of how far you can go. And that says the freedom to be non-offensive is not worth having. So generally speaking, people are allowed to say things that other people might find offensive and might find provocative. This was a case of somebody who was actually preaching in public and he was winding people up and he was arrested for breach of the peace. And the police said, well, we need to do this because you talking is going to get people beating you up and that's going to be, we can't be encouraging that. But the court said, well, no, you should arrest the people who are going to beat him up, not him. And like I say, I do like that sort of phrase, the freedom to be non-offensive is not worth having. So we've always had this idea of rights, but they are what we call qualified rights. So they can be restricted in as far as is necessary in a free and democratic society. So that is things like, defamation, for instance. There's no, the argument is there's no public interest in telling lies about people, but also things like incitement to crimes, certain sorts of, distasteful subjects. You can't be sort of broadcasting pornography. all that sort of thing. So there is that tension there. Now what the BSB say is they're less bothered about what our views are, because, you know, we have a right to hold certain views. It's more on how we express those views. So you can actually, you know, hold very controversial views, and you can discuss those, and you can make it clear you hold those views, so long as you do it in a sort of polite and respectful manner. Although having said that, ooh, that's a lovely view. Hang on, I'll just get you that one. Now, one of my friends actually, and Chambers colleagues, she went to the BSB complaining because fellow barristers had been criticising some of her comments, but using the C word to do it. And the BSB actually said, no, that's fine. You know, you just got to have a thick skin about such things. So, you know, we aren't given a lot of leeway there. But to express one of my personal opinions, what I get concerned about is there are some barristers out there who give opinions on the law, and I would say they're doing it for political reasons. They're not just getting the law wrong, they are misinterpreting the law. And that's causing a lot of confusion for people, especially with everything that's going on at the moment. Because, you know, for instance, they've been misquoting the rules under the Terrorism Act and saying, oh, you know, so that implied that people were being arrested unlawfully, whereas actually they weren't. And that, I think, is dangerous. Now, obviously, you know, I rant on here, and sort of getting things wrong is part of the brand, really, isn't it? You know, I get place names wrong, people's names wrong. I'll try not to misquote the law too much. I mean, a lot of people say, we really like how you express the law in lay people's terms and not legalese. To be perfectly frank, that's because quite often I can't actually remember exactly what the statute says or the relevant passage from the case law or the law reports. But, you know, I do think we have a bit of a duty to try and get things right. Because, you know, people watching this channel, if they're going to go away and say, oh, well, a barrister told me, and that's why we're very clear to say, look, this is just guidance, it's not legal advice, and, you know, it doesn't come with any warranty, you know, my thing, vaguely accurate. But interestingly, when I was over, because when I do all the advocacy training, one of the things I actually train is ethics and stuff, and that includes your sort of conduct, you know, your interpersonal conduct, including online. And I was doing this over in Sierra Leone, and one of the things I have to do is actually prepare some guidance on social media for the Sierra Leone bar. I think it's going to turn out to be suspiciously similar to the Bar Standards Board advice. Ow! Just tripped over a rock on social media, and then we can have a big row about copyright and IP. But yeah, generally speaking, like I say, you know, there is this duty on us to be careful of what we say on social media, because the other thing we have to show is that we have independence and that we will fearlessly represent anybody because of the cab rank rule without concerns for what that impact on us, you know, our personal reputation, even, you know, our personal safety. We can't refuse to represent somebody just because people might beat us up for representing them. That's one of the reasons that, you know, we wear all the fancy dress, because the argument is it makes us harder to recognise. That certainly pays off, actually. I remember once being stood at Harrow train station after a particularly messy criminal trial, and there were some people there who did not like us because of some of the cross-examination. And luckily, hello! And luckily they didn't recognise us because we were no longer in our fancy dress. But we have to show that we are independent and that we will represent people. So if we express views where somebody might say, well, hang on, you've expressed that you don't particularly like people like me, can that person then feel safe being represented? Well, actually, the BSB have said, well, yeah, actually, yes. So say, for instance, you hold gender critical views. I'm not going to get involved in the merits of that topic, but you can express gender critical views, and the Bar Standards Board said, well, that doesn't necessarily mean you won't do your hardest if you're representing a trans person. I mean, this cab rank rule causes all sorts of issues. You know, we do all the animal rights stuff, but quite often, because we allegedly have an expertise in sort of animal rights law, especially, you know, prosecuting and bringing cases against, you know, dodgy farms and dodgy meat processing plants and stuff like that, and I do all the stuff for the undercover investigations. But a lot of the time, the people being prosecuted for these offences go, can you defend us? Because you seem to know a lot about this sort of thing. And we have to do it. Cab rank. So, you know, I was pretty much resident counsel to the fishing fleet down here, and I do a lot of work for farmers and dairy farmers and people like that. Even though, you know, people know my views and the annoying vegan thing. Hello! Oh, lots of people out on this miserly day. Glad to see it. Because apart from anything else, that means the cliff path hasn't collapsed if they're coming this way. So that's the barrister thing. So to summarise, yes, we have certain freedom of expression rights, but they are a bit limited compared to your average member of the public, because we can get into trouble with the regulator if we go too far. What about this extradition thing? The police have said, well, even if you put something from abroad, we will get you. Well, can they do anything about that? Can they extradite you? Now, first of all, just to do one of my nerdy things, when it comes to extradition, it's the country requesting the person that is extraditing. The country that hands them over is rendering. You might remember all that extraordinary rendition back in the War on Terror days, which was basically just shoving people on aeroplanes and dropping them off in like black sites around the world. But extradition is governed by treaties. We do have an Extradition Act, Extradition Act 2003, that sort of sets out some of the procedures. But generally speaking, we have arrangements with lots of different countries. So say, for instance, because of our previous membership of the EU, we still sign up to the European arrest warrant. So there's a bunch of countries where the test for extraditing somebody is just, could you have actually nicked them in this country? You know, could you have issued a warrant in your own country? If you can, it's the same as, like, you know, somebody in Manchester issues a warrant for somebody in London and they can arrest them. They could also issue a warrant for somebody in Paris, and the French authorities would just hand them over. So the standard there is, if you've passed the test to get an arrest warrant in this country, you know, which is just reasonable suspicion, then they will extradite. Then we come on to the two other things where it's whether or not you need to show a prima facie case. So there is a big list of countries where actually it's pretty much the same test as the European arrest warrant. You know, do you have reasonable suspicion for suspecting this person has committed an offence? If so, subject to a proviso I'm going to come on to, they will actually just they will just render them for you. But there are other countries where you have to show that you actually have a prima facie case. So it's not enough just to say reasonable suspicion. You actually have to say, look, here's all the evidence we've got, and on the face of it, there is enough here to convict them unless they can come up with a spectacular defence. The other thing you need to show is duality. In other words, the offence you're trying to extradite somebody for has to be an offence in both countries. It doesn't have to be called the same thing, but it has to be, if you do this factual thing, that would amount to an offence in that country. And I think this will be a big problem with extraditing people from, say, the US, because obviously they have much stronger First Amendment rights over there. I mean, things that we would classify as hate speech, it is quite protected over there. I mean, they do have all the same old stuff. You know, you can't shout fire in a crowded theatre. They have the fighting words doctrine and all that sort of thing. You know, you can't be going out provoking people. But especially with so-called political speech, then people have a lot of protections. So I think it'd be very, very difficult to extradite somebody from the US, even if they had done some of the things over here that have got people arrested. I mean, you've probably seen that thing that guy got done for posting on social media about going to the hotel. Now the thing there is somebody had already set fire to that hotel, and he went basically go down and do it again. So it's perhaps unsurprisingly that he got done. I mean, he did plead guilty. It would be interesting, and no doubt some people will go not guilty on these and run an Article 10 argument, and I'll keep an eye out for all those sorts of things. But I just can't see that the US will do this. Also, there is a political dimension, because even if you've satisfied all the legal tests and the court is happy, the ultimate decision is usually won by a politician. And in the same way, like, the US wouldn't extradite that lass who ran the lad over by driving on the wrong side of the road. In all fairness, Theresa May, she wouldn't extradite that lad who did all the hacking. into the computer systems in the US. So, you know, there is always that filter there, and that's, you know, the interface of politics and law. But so there you go. So yeah, in summary, there is a theoretical possibility of extraditing people who post things from abroad. I mean, you also get into where was the offence committed, especially when it's online. I mean, let's say, you know, I build an explosive device in this country and post it to somebody in another country where it explodes. Well, obviously, bombing people is an offence. But where did the offence take place? Did it take place where the bomb went off or where I assembled it? And these are all the sort of interesting legal arguments you get. And it's the same thing with posting online. You write the tweet in one country, but people read it in another and are thus incited. So where is the offence committed? If the police do try to extradite people, I think all this will be tested. My guess is that they won't actually do that because, you know, they've got limited resources and they are pragmatists. I think they'll realise that they don't really stand a chance. So anyway, there you go. As always, hope you found that vaguely useful, vaguely interesting, vaguely accurate. Where am I today? I'm just walking along the north coast, and I've just gone past a place called Hell's Mouth, which, had it been less misty, I would have got you some better footage of it, but it's just like a really spectacular drop with all cliffs and rocks and crashing waves. A few years back, we had to get rid of an old piano, and we were really tempted. We actually wanted to bring it up here and just throw it off the edge. You know, eco-friendly, you know, so it'd form a little reef for all the sea life and things. You know, we weren't going to pollute it. But then we actually realised that it's quite an actually long walk from the nearest car park. so it's like, how are we actually going to get it up there? So we abandoned that idea and just put it on a low loader and took it to the tip.